Major breaking news out of the United States Supreme Court, potentially good news, but it's complicated. I'm going to break it down for you so you understand exactly what's going on in just one moment. Hey folks, it's Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Down, our Second Amendment channel, please do so. We're working really hard to try to get to 100,000 subscribers as fast as possible to help us with the social media algorithms. All right, so the major news today out of the United States Supreme Court. Specifically, the U.S. Supreme Court came out with an order directing the state of New York to file on or before January 3rd their official brief or position paper as to why the United States Supreme Court should not vacate, meaning get rid of, the Court of Appeals stay signed off by and ordered by the Court of Appeals for the Second Circuit out of New York. Now, again, the breaking news is this, and then I'm going to break it down why it's important, potentially. The Supreme Court today entered an order telling the state of New York to file a brief in response to a request by the lower court plaintiffs, Ivan Antonyuk and others, who, if you may recall, we've covered it before, in major victories. Mr. Antonyuk and his esteemed counsel and his colleagues, other plaintiffs, brought lawsuits challenging the new gun control laws that were designed by the state of New York to get around the NYSERPA versus Bruen decision. If you may recall, NYSERPA versus Bruen held that may issue permitting regimes that gave the government the authority to determine who was entitled to a carry permit and who was not entitled to a carry permit. Those were unconstitutional under the Second Amendment's right to keep and bear arms. So immediately what states like New York did is they tried to thumb their nose at the U.S. Supreme Court and its decision in NYSERPA versus Bruen. And by the way, if you've been watching this channel from the start, you know I predicted this literally months before NYSERPA versus Bruen was decided. What they did, what the state of New York did, is they went out there and they tried to create new criteria for how you got your permit, and then they also tried to define so much of the state of New York as a quote-unquote sensitive place, which is a euphemism for government-mandated gun-free zone. Now, in a over 140-page decision by Judge Sotheby, the federal district court in the Northern District of New York, he entered an order declaring much of, not all of it, but the bulk of it, the bulk of New York's new anti-gun gun control laws enacted after Bruen, to be unconstitutional under NYSERPA versus Bruen in the Second Amendment. Judge Sotheby then went on to say that because those laws are unconstitutional, he is going to enjoin them from being enforced. Now, enjoin means simply he's going to bar them from being enforced by the relevant defendants, the government defendants. So that is what Judge Sotheby did. A major victory for the Second Amendment. We covered it on this channel. So then the state of New York then sought what's called an emergency appeal or an emergency application to the Court of Appeals for the Second Circuit, which is the Court of Appeals overseeing the district courts, including Judge Sotheby. And New York said, please, oh please, stay, which means to pause or freeze, stay Judge Sotheby's decision that basically declared much of these new laws unconstitutional. And the Second Circuit, after considering for a while, issued a 3 or 4 sentence order that stayed the lower court's decision, which means that even though the lower court with Judge Sotheby declared the bulk of New York's new concealed carry laws to be unconstitutional, the Second Circuit Court of Appeals basically put the brakes on that decision and allowed all those new New York gun control laws to stand, to continue to be enforced and used against people, including presumably to have people be arrested and prosecuted under them. So what the plaintiffs did in the Antonyuk case and their counsel is they obviously were displeased, and rightly so, with the Second Circuit's decision to stay the lower court's decision. So they sought an emergency, and this is a little bit unorthodox in my opinion. not bad, just a little bit unusual given the procedural posture, not bad or anything like that. They sought an emergency appeal to the United States Supreme Court, basically arguing in a very compelling brief that you have this erudite, detailed, factual, and legal analysis set forth by Judge Sotheby in the Northern District of New York. A very powerful piece of evidence, a very powerful piece of scholarship and legal writing and thought. And then you have the Second Circuit Court of Appeals in a couple sentences seem to blow it off and simply say, nah, we're going to grant the state stay. We're going to let these laws continue to be enforced, even though we have a 140-page detailed decision. By the way, there's other opinions out there. Don't forget Judge Sinatra in a separate case in the Western District of New York in Buffalo also found parts of that New York concealed carry law to be unconstitutional. And the Second Circuit stayed that decision as well. So the plaintiffs in the Antonyuk case went to the United States Supreme Court and said, this is ridiculous, basically, that you have these powerful lower court decisions, in particular the Antonyuk case. And then the Second Circuit essentially writes this sort of perfunctory few-sentence decision to stay the lower court decision, which means that all of our clients' Second Amendment rights are going to continue to be violated for months and months and months on end and for who knows how long, while the Second Circuit, waits to determine the actual full-blown appeal, which is going to take many, many months. Because that's what we're talking about here. What's going to happen during the duration of this appeal? Is the lower court opinion going to stand, which means these laws cannot be enforced in New York? Or, alternatively, the way it is right now is these laws are all going to be maintained and can be enforced pending the outcome of the appeal in front of the Second Circuit. So the plaintiffs, the Antonyuk plaintiffs, then sought this emergency appeal to the U.S. Supreme Court saying, again, this is ridiculous, this is wrong, the Second Circuit stay of the lower court's decision needs to be vacated, and the lower court's very erudite 100-plus page decision should be the law of New York pending the Second Circuit's full-blown decision in this case. When in doubt, the constitutional rights of Americans should be upheld and not these decisions by the state of New York to violate them. That's essentially the compelling brief, the compelling arguments that the Antonyuk plaintiffs made. And it was very good. So what's interesting, though, is when the Supreme Court decides a case like this, and this is where it gets complicated, there's three things that the U.S. Supreme Court considers when they decide whether or not to grant a stay, or alternatively, in this case, to vacate a stay by the Court of Appeals. They first ask themselves, is this important? I think obviously this case is important. I think the court would agree it's important. They also then ask, is there a circuit split? Meaning, are there different cases coming out different ways in the Court of Appeals? As of now, that's not the case because this is so new after Bruin, there is no circuit split. And the third one, and this is where I think if the plaintiffs in Antonyuk lose before the Supreme Court on this application for a vacation of the stay, this is where I think they get tripped up. It's nothing they can do about it. It's just kind of the procedural posture of the case. Specifically, this appeal is occurring on what's known as an interlocutory basis. And this is a big word, but it's not that complicated. Interlocutory. An interlocutory appeal refers to an appeal that occurs during the pendency of a case. So whether it be a criminal case or a civil case, they take time. If there's an appeal made during the case, but not at the end of the case, it's called interlocutory. Most appeals occur at the end of the case, after someone has been convicted of a crime, after someone has lost a lawsuit, after someone's case has been dismissed. Whatever it is, at the end of the case is when you take your appeals and the appellate courts then look at the case. But because of the nature of the Antonyuk case, this is not a final judgment down below. It's a preliminary injunction where there's going to be many more, could be many more months, if not years of this case pending before it's finally resolved. So the emergency request for a stay to the Second Circuit was based on an interlocutory basis, and now the emergency request to vacate the Court of Appeals stay to the U.S. Supreme Court is also being done on an interlocutory basis. Again, what interlocutory means is the case is not over, it's not been fully adjudicated. Now, the reason why this is so important to the U.S. Supreme Court is because they handle so few cases, they really only like to get involved if possible, when it's toward the end of the case or at the end of the case where all the facts are known, all the information is out there, all the legal arguments have been vetted, and this minimizes the chance of the Supreme Court making a mistake, which they desperately don't want to do because anything they say or do has so many major implications for the rest of the country. So they don't like to get involved when a case is partially done because they really want the maximum amount of information in front of them before they make major decisions. And because this case involving Antonyuk is on an interlocutory basis, it's possible the Supreme Court could just simply say, we're going to deny this request for an emergency application simply because of the procedural posture. We may agree with the plaintiffs entirely, but we don't want to weigh in just yet. We're going to give the Second Circuit Court of Appeals the chance to resolve this appeal, get it right on their own initiative. If they get it wrong, then they're going to come back to us and we'll deal with it then when we have more information. So we just don't know what the Supreme Court's thinking right now, but the fact is that the Supreme Court has asked for a briefing from the state of New York is a sign that the court itself has taken this very seriously and they want to see both sides to this debate. They did not just blow it off and deny the motion for an application to vacate the lower court stay, which they had the right to do. The Supreme Court could have just said denied. They didn't do that. They actually have asked for a briefing from the state of New York, and that, I would say, is a possible good sign. It's not dispositive, but it is a good sign that the court has taken this seriously. And of course, I think the best possible outcome that we're going to cheer for would be the Supreme Court vacates the Court of Appeals stay of the lower court decision with a little notation that says something like, you know, we have a very erudite District Court of Appeals opinion. We find it to be very well thought and well reasoned, and we do not see any reason in the Court of Appeals for the Second Circuit's 3-sentence, grant of the stay to overcome that very well-written, erudite opinion by the lower court. So we're going to vacate the emergency stay entered by the Court of Appeals for the Second Circuit because we just don't see the basis for it. That would be the best possible outcome, but I do think there's a good chance that it will not succeed, not because of the merits, but because of the procedural posture. And the court often doesn't like to get involved with cases prematurely. And I think that at the end of the day, I do think the Antonyuk plaintiffs are going to prevail in their case. The question, though, is when will that officially occur and the way it goes about doing. But certainly we're cheering for them to win before the U.S. Supreme Court, and that may very well occur. But if it doesn't occur, I would not get depressed about it because I could see it being denied, again, on procedural basis grounds having nothing to do with the merits of the matter. On the other hand, if they do, if the Supreme Court does vacate the Court of Appeals stay by the Second Circuit, if they do that, that will be a huge victory for the Second Amendment because it will be a major signal to the courts of appeals and all the courts across the country that the Supreme Court will not wait 14 more years to make sure that lower courts enforce and apply properly their decisions, including in Heller and NYSERPA versus Bruin. Okay, I know this is a little complicated. I hope you learned a little bit something about interlocutory appeals. We got our fingers crossed for the Antonyuk plaintiffs and their counsel. And I believe this is sponsored by the Gun Owners of America, as I recall. So, we're cheering for them. And hopefully they do prevail before the U.S. Supreme Court on their request for a vacation of the Court of Appeals stay. Okay, we'll see you again soon. If you haven't subscribed, please do so. And we'll see you again soon. 4 Boxes Diner.
Orders up. Table 2A.